Okay, good morning, everyone. We're going to go ahead and get started. Welcome and thank you all for joining us this morning for our webinar, Trending Events in Education Law, Part 1 of a 3-part legal and legislative update series. This webinar is being presented this morning by the Education Law Group of Roetzel and Anderson, LLP, and Roetzel Consulting Solutions. My name is Susan Anderson, and I'm a shareholder at Roetzel and Anderson, and I'm the practice group manager of the Education Law Group. Joining me today as speakers are several members of our education law team, which includes Lisa Burleson, Lisa's a shareholder in our Columbus office, David Hirt, David is a shareholder in our Akron office, Tom Allen is a shareholder in our Cincinnati office, Sherri Warner. Sherri holds a couple different titles. She is of counsel to Roetzel and Anderson as an attorney, and then she's also a director at Roetzel Consulting Services in Roetzel's Columbus office. And then last but certainly not least, Aaron Ross will be joining us as a speaker as well. Aaron is an associate in our Columbus office. We are going to start this morning with David Hirt and me talking about the new Title IX regulations. And then after that, we will hand it over to Sherri Warner and Aaron Ross, who will speak to you about a legislative update, a review of legislative status of bills concerning transgender students, property tax laws, and religious education in public schools. And then our last segment this morning will be presented by Lisa Burleson and Tom Allen. And that segment is a legal update, a review of the current state of the law as it relates to the social media used by districts, transgender student rights, and administrative agency happenings. So in terms of Q&A, we are going to reserve some time at the very end after all 3 segments for questions. If you have any questions, you can submit those at any time in the Q&A box that you should see at the bottom of your screen. And then finally, I don't want to forget to remind you all that this is part 1 of a 3-part series. So please mark your calendars for part 2 of the webinar series, which will be happening on September 12th, Thursday, September 12th. And then part 3 is scheduled for Thursday, December 12th. And, keep an eye out in your email closer to those dates for details on the subject matter that we'll be addressing in those webinars. Okay, so with that said, we are going to go ahead and jump into the first segment, which is discussing the new Title IX regulations. And as I mentioned, that discussion will be led by me and David Hirt of our Akron office. Okay. Bear with me. Okay, there we go. Bear with me a moment. I'm having a bit of a technical difficulty. There we go. Okay. Okay. So as I mentioned, we are talking first this morning about the Title IX, the April 2024 regulations. Okay. Okay. So I'm sure that everyone is aware that the 2024 regulations were released on April 19, 2024, almost 2 years after the proposed regulations were released in July of 2022. These, the April 19th regulations include significant clarification as to how OCR will enforce Title IX, and they include changes as to how public K-12 school districts must address complaints of sex-based harassment. So that's the terminology used in the 2024 regulations, as opposed to sexual harassment. That was a term used in the 2020 regulations. And the 2024 regulations are effective on August 1st, 2024. So those are the regulations. The new regulations are what you all need to be operating under when you have a complaint, Title IX complaint, that alleges misconduct misconduct that occurred either on August 1 or after August 1 of 2024. So, typical of governmental agencies, they don't give you all a whole lot of time to get up and running under the new regs. So we hope that this morning's segment will help you at least get started on your preparation for the implementation of the new regs. So when the Department of Education announced the new regs in April 29th, in their press release, they specified that the final regulations were designed to promote educational equity and opportunity for students across the country, as well as accountability and fairness, while empowering and supporting students and families. The DOE went on to say that the final regulations restore and strengthen vital protections for students, provide schools with information to meet their Title IX obligations, while offering appropriate discretion and flexibility to account for variations in school size, student populations, and administrative structures. So in other words, I think the DOE is kind of touting this as it's not a one-size-fits-all process for school districts, as it was under the 2020 regulations. Okay, so I mentioned already, and what we're going to do this morning is kind of do a comparison and a contrast between the 2020 regulations and the 2024 regulations on some key components. Now, keep in mind, that the final rule that was published was close to 1,600 pages long. So we're obviously not going to be able to hit all of the components of the final regulations here this morning, but we have designed this webinar to try to hit some of the key pieces that we know as lawyers who assist public boards of education, their administrators, and implementing Title IX investigations. We're hitting the key points that we see in our practice that are some key questions for school districts. So in terms of the terminology used under the 2024 regulations. So as I already mentioned, in 2020, those regulations use the term sexual harassment, and that term was defined as conduct that occurred on the basis of sex, that is quid pro quo harassment. It included hostile environment harassment, it included sexual assault, dating violence, domestic violence, and stalking. So in 2024, today, the regs use the terminology sex-based harassment. And in coining that term, the Department of Education has really broadened the category of conduct that falls under Title IX, and it explicitly defines sex-based harassment as meaning sexual harassment and other harassment on the basis of sex, including on the basis of sex stereotypes, sex characteristics, pregnancy and related conditions, sexual orientation, and gender identity. So this is important because, under the 2020 regs, so the 2020 regs came out and they were controversial to, in the opinion of some folks, because some folks felt that the 2020 regs perhaps inappropriately focused on the rights of the respondent, the person being accused of the misconduct, and less so on the rights of the complainant. And so the 2020 regs also really didn't answer the question of, can there be a violation of Title IX if there is conduct motivated based on someone's sexual orientation or gender identity? And then we had all these court cases, that kind of dealt with that question in different ways. Some said, yes, gender identity was included, sex stereotyping was included. Some said no. And then certainly when the Biden administration came into place, and the DOE issued a notice of interpretation after the Bostock case, which applied the definition of sex to include gender identity and sex stereotyping. So then the DOE issued their notice of interpretation saying that we are going to apply that also to Title IX, and then there was a lawsuit that enjoined that. So there was a lot of contrary advice and opinions out there that really led to school districts not really knowing exactly what they needed to do if they had a Title IX complaint that was based on gender identity, transgender status, sexual orientation, that kind of stuff. So, school districts kind of had to weigh what was out there and decide what they felt was legally applicable to their districts. So now here we are with the April 2024 amendments that clearly specify that gender identity, sex stereotyping, sexual orientation are covered under Title IX. And so misconduct alleged on the basis of those categories is a covered misconduct under Title IX. So it takes that question out for school districts. And in doing so, it really follows the reasoning of the Bostic decision that I mentioned earlier. Okay. So this is also key. The 2024 regulations explicitly prohibit a school district from separating or treating any person differently based on sex in a manner that subjects the person to more than minimal harm unless it's otherwise permitted by Title IX. And so treating someone differently on the basis of sex under Title IX would be permissible, for instance, in terms of things like sex-based athletic teams or like Girl Scouts and Boy Scouts, that sort of thing. But in saying that and using that as an example, I do want to make clear that these new regs do not apply to athletics. In the press release, the Department of Education specifically said that, they don't apply to athletics. That is, those rules are still under consideration. The athletic rules were released separately. Those were released for review and commentary in April of 2023. And received over 150,000 comments. So those rules are still under consideration. So, particularly in the context of like how transgender athletes are going to be treated under Title IX and what their participation in athletics will be under Title IX is still an open question. We are still waiting for the answers from the DOE on that. Okay. So facilities, again, I'm probably going to say that everything we're talking about is important, and it is because that's why we decided to include it. But the 2024 regulations answer one of those questions that were kind of an open kind of quagmire for districts as it relates to facilities. So in 2020, the regs said that a school district may provide a separate toilet, locker room, and shower facilities on the basis of sex, but the separate facilities had to be comparable. The regs in 2024 now very explicitly say that a school district is prohibited from discriminating in the provision of facilities based on sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, or gender identity. So these are the questions that I get quite a bit of in my practice, and I know my partners do too, in terms of, okay, we have a transgender student who was assigned male at birth, but now identifies as female, and that student is asking to use the female locker room or the female bathroom consistent with their gender identity. Under the 2020 regs, it was really kind of a debatable question in terms of whether or not a school district must allow them to do that, may allow them to do that. All of those were kind of open questions. In 2024, the DOE has made clear that you cannot discriminate against a student who wants to use the bathroom that is consistent with their gender identity. And what the regs say is that adopting a policy or engaging in a practice that prevents a person from engaging in an education program or activity consistent with the person's gender identity subjects a person to more than de minimis harm on the basis of sex. So in other words, what they're saying is if you as a school district exclude a student from being able to access the bathroom facility on the basis of their gender identity, that these regs have determined that that is kind of a per se more than de minimis harm to that student on the basis of their sex. The regs are, so then, if the regs are now saying that, okay, districts, you must allow students to use the bathroom on the basis of their gender identity, the regs do leave open the question of what do you do with non-binary students? And those are students that, have identified themselves as not being tied to one gender or the other, but kind of I think another term that you hear for that is gender fluid. That is kind of an open question in the regs. So that is something that a school district is going to have to analyze on a case-by-case basis. And as you all probably know, there's been a lot of use of unisex bathrooms, and there's been more unisex bathrooms popping up in school buildings as a way to try to solve this problem of, okay, if you have, a student who wishes to use a bathroom on the basis of gender identity, a lot of school districts would then, under the 2020 regs, offer a unisex bathroom as kind of a middle ground. The 2024 regs say that a unisex bathroom is still permitted as an option, and but districts are not required to implement a unisex bathroom under the new regs. Okay. So also because of, all of the conflicting court decisions and rules interpretation and that sort of thing, under the 2020 regs, it was really kind of, again, an open question on, which controlled. Was it the Title IX regs? Was it federal court cases? Was it state law? And here the 2024 regs resolve the answer to that question for us and explicitly say that the obligation to comply with Title IX and these 2024 regs is not obviated by any state law or local law that may be contrary to Title IX. So for example, if the Ohio General Assembly does enact legislation that would require a public school district to only allow students to use district facilities that are in accordance with their gender assigned at birth, even though we would have an Ohio law that says, okay, students, you can only use a bathroom that's consistent with your gender assigned at birth, Title IX says otherwise, so Title IX wins. In other words, Title IX preempts the state law. And this is something to keep an eye on because, my colleagues Sherri and Aaron are going to be talking to you about a bill that is currently pending before the Ohio legislature that would do exactly that. That would restrict a school district's ability to allow students to use bathroom facilities that are consistent with their gender identity. So that's something we're certainly going to continue to keep an eye on, and we'll be able to advise on as that bill goes through the Ohio legislature. Okay, so then, kind of going back to our compare and contrast model. So the 2020 regs, in terms of hostile environment harassment, the 2020 regs define hostile environment harassment as unwelcome conduct on the basis of sex determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the recipient's education program or activity. And under the 2020 regs, the misconduct must be severe and pervasive, as well as objectively offensive. And this definition was a big change in 2020 from the prior regs, which was a broader definition and didn't use the word "and," rather it used the word "or." And what we see in 2024 is a movement back to that broader definition of hostile environment harassment. So the 2024 regs specify that hostile environment harassment means unwelcome sex-based conduct that, based on the totality of circumstances, is subjectively and objectively offensive and is so severe or pervasive that it limits or denies a person's ability to participate in or benefit from a recipient's education program or activity. So the conjunctives are important here, right? So as I said, in 2020, it was severe, pervasive, and objectively offensive. Here it is severe or pervasive. So in 2024, severe or pervasive. So what that means is in 2020, if you had a pretty significant incident of misconduct that was based on sex, but if it was like a one-off issue that hadn't been repeated in the workplace, let's say, then that may not have reached the definition or met the definition of hostile environment harassment because it would not be considered severe and pervasive. Here in 2024, those kind of one-off incidents of misconduct under this definition would meet the definition of hostile environment harassment. So that's something to keep in mind. Okay. The 2024 regs also address pregnancy-related conditions and, kind of like what it did for the hostile environment definition. These 2024 regs have really kind of broadened the category of conduct that falls under their pregnancy-related regulations. So in 2020, the regs prohibited discrimination against students or employees based on pregnancy, false pregnancy, termination of pregnancy, childbirth, or recovery from childbirth. And it did specify that parents cannot be treated differently on the basis of sex, where in 2024, it defines and it prohibits discrimination against students or employees based on current, potential, or past parental, familial, or marital status. So, those are obviously broader terms, broader categories that are being used in the 2024 regs. So, and the DOE in announcing the regs, specified that the final regs strengthen requirements for schools to provide reasonable modifications for students based on pregnancy-related conditions. For instance, the 2024 regs now specify that districts must provide reasonable break times and a reasonable location for lactation breaks for students. So for instance, students must be permitted to have breaks from class time in order for lactation related reasons, which would include potentially, pumping as well. And then the 2024 regs also require that when a student or a parent of a minor student informs a school employee of a student's pregnancy or a related pregnancy condition, that then the student must be provided with information about the school's obligations under Title IX to prevent discrimination and to ensure equal access for that student. And it also prohibits school districts from disclosing personally identifiable information that they obtain through the Title IX process, including any information about reasonable modifications that are provided to the student. So in other words, the regs say that, a student who is pregnant and who may be subject to some reasonable modifications because of that pregnancy, the school district has to keep that all confidential. All right. Okay. So now we're going to move into the scope of the grievance process. I'm going to talk just a minute about this, and then I'll hand it over to my colleague, David Hirt. But under the scope of the grievance process, under the 2020 regs, a school district must apply its Title IX grievance procedure to sexual harassment if the alleged misconduct occurred in the United States and as part of the district's educational program. So in other words, the 2020 regs very carefully excluded things such as misconduct that might occur when students are on let's say an international trip during their senior year, or it excludes misconduct that's alleged to have occurred in a study abroad program. Here in 2024, the regs have expanded the geographical reach of Title IX and said that Title IX still applies to a sex-based harassment complaint, even if some of the conduct is alleged to have occurred outside of the United States. And if some of that conduct is alleged to have occurred outside the United States, that conduct must be addressed through the grievance process. So with that, I'm going to hand it off now to David Hirt, and he's going to finish up our segment on Title IX this morning. David, take it away.
Thank you. My part of the talk is going to focus more on the mechanics of the Title IX grievance process. If you remember, under the current 2020 regulations, the phrase formal complaint was used, and that had to be a written complaint. And that is what caused the school district to have to initiate the formal grievance process. The 2024 regulations make a pretty major change. Now, what initiates the grievance process is simply a complaint, and it can be in writing, but could also be verbal. So under the 2024 regulations, if you get a verbal complaint that you understand to be a request for an investigation, that means that you are required to initiate your Title IX grievance process. Just like with the 2020 regulations, under the new regulations, the complaint can be made by the alleged victim, and if that is a student, the parent or guardian can initiate the complaint. A legal representative of the student can initiate, or of an employee can initiate a complaint. Or just like in 2020, the Title IX coordinator may be able to initiate the complaint, even if the student or the parent or the employee doesn't want that. What has changed under the 2024 regulations is that previously the Title IX coordinator had, for the most part, pretty much unfettered discretion to decide whether or not he or she would sign the formal complaint, even if the complaining employee, student, or parent didn't want to. Under the new regulations, the Title IX coordinator, can still initiate the grievance process. But now the Title IX coordinator has to consider certain factors when deciding whether to do that. And then there's a test at the end after considering those factors that is supposed to guide the Title IX coordinator in his or her decision whether or not to initiate the grievance process, even though the student, parent, or employee doesn't want to. So there are 8 factors now that the Title IX coordinator must consider. And the first one is pretty obvious. Just think about why the complainant, whether that's a student, parent, or employee, doesn't want to go through the grievance process, and give those reasons the consideration that you, as the Title IX coordinator, think that they deserve. Consider whether or not the potential complainant has expressed any reasonable safety concerns, and that would mean whether or not the grievance process is started or is not started. You're supposed to consider, as the Title IX coordinator, whether there's a risk that additional sex discrimination would occur if you don't go through the grievance process. You're supposed to consider what is the severity of the alleged misconduct. So obviously, this factor is if the alleged severity is relatively slight, that might weigh in favor of not initiating a complaint against the wishes of the complainant. But you might think that then if the alleged misconduct is more severe, that you should initiate the grievance process regardless of the wishes of the complainant. You need to consider the age and relationship of the parties, and especially whether or not the respondent is an employee or a student. Here, if the alleged respondent is an employee and the complainant is a student, that would probably weigh in favor of initiating the grievance process. You're supposed to consider the scope of the alleged misconduct. Is there a pattern of ongoing discrimination, or is it a single event? Is it a single individual that's being affected? Or have you learned that there are multiple individuals who have been affected by the respondent's misconduct? You're also supposed to consider the availability of evidence for a decision maker. So in this sense, I think that you're sort of supposed to act as a prosecutor would in a criminal case. You're supposed to evaluate what type of evidence can you get from the complainant and maybe witnesses. And if you decide that, well, maybe the complainant really isn't able to provide you with sufficient evidence, that's a factor that suggests that maybe you don't go through the grievance process. And then finally, the last factor is consider whether or not the district can end the alleged misconduct and prevent reoccurrence without going through the grievance process. So once you've, as the Title IX coordinator, once you've considered all of these factors and any other factors that you believe are relevant, you're supposed to initiate a complaint against the wishes of the complainant, parent, or employee only if you decide one of two things. First, does the conduct that's alleged present an imminent and serious threat to someone's health or safety? Or does the alleged misconduct prevent the school district from ensuring equal access based on sex to the district's program and activities? I think that the first factor, or the first part of this test, is supposed to be a relatively high bar. Does the misconduct present an imminent and serious threat to someone's health or safety? The second part of this test, to me, is a relatively low bar. Is the misconduct preventing the district from ensuring equal access to its program? If you, as the Title IX coordinator, decide to initiate a complaint, even though the complainant, student, the parent, or the employee doesn't want you to, you're supposed to give notice to the complainant that you're going to do so prior to initiating the process. And if you haven't already done so, discuss with the complainant possible supportive measures. And if you agree on supportive measures, initiate those supportive measures either before or at the time you initiate the grievance process. Another change in the 2024 regulations has to do with informal resolution. Under the old regulations, the informal resolution process, which to me usually meant some sort of mediation, was available only if the complainant filed a formal written complaint. But the informal resolution process was not available if the allegation was sexual harassment by an employee directed at a student. Also under the old regulations, it was possible for either the Title IX coordinator or the investigator to serve as the mediator for a possible resolution, but neither a decision maker or an appeal decision maker could serve in that role as a mediator or facilitator of an informal resolution. The 2024 regulations make some changes to that. Now the district may, but is not required to offer informal resolution at any time before a decision maker issues a decision. But like the old regulations, informal resolution is not appropriate where the allegation is sex-based harassment by an employee that's directed at a student. Another change that the 2024 regulations make is that the investigator who's assigned to the grievance process cannot be the mediator or the facilitator. And like the old regulations, nor can the decision maker or appeal decision maker be the mediator. The Title IX coordinator is still able to be the mediator unless the Title IX coordinator is serving in one of those additional roles. The 2020 regulations had really no language about any additional procedure to go through if the complainant or the respondent was a child with a disability pursuant either to IDEA or Section 504. The 2024 regulations state that if the complainant or the respondent is a child with a disability, the Title IX coordinator now must consult with one or more members of the student's IEP or Section 504 team to determine how the district is still going to comply with requirements of IDEA or Section 504 during the grievance process. And to me, this means a discussion between the Title IX coordinator and one or more member of the student's team to talk about or to make sure that any supportive measures that are going to be implemented don't interfere with complying with the student's IEP or the Section 504 accommodation plan. In the old 2020 regulations, one of the steps in the grievance process was before the investigator completed his or her final report, the investigator had to provide both parties with the evidence that the investigator had gathered and give the both parties the opportunity to respond to the evidence before the investigative report was finalized. That's changed a little bit with the new regulations. Now the regulations say that the district, meaning the investigator, must provide each party with an equal opportunity to access either the actual evidence or an accurate description of the evidence. But if the investigator provides only an accurate description of some piece of evidence, the parties, one or both parties, may still ask to see the actual evidence, and that request must be complied with. To me, I think this applies mainly to maybe written statements that the investigator obtained. So under the old regulations, the investigator was supposed to provide a copy of the actual written statement. Now the investigator may try to get away with just providing a description of the written statement, but the investigator will have to turn over the actual written statement if one of the parties requests it. A change has been made to the function of the decision maker or the role of the decision maker. Under the 2020 regulations, it was permissible for the Title IX coordinator to also be the investigator, but neither the Title IX coordinator nor the investigator could serve as the decision maker or the appeal decision maker for that matter. Under the new regulations, the Title IX coordinator may continue to also be the investigator, but now the Title IX coordinator, even if that's the only role that he or she plays, or if the Title IX coordinator is also the investigator, that person can also be the decision maker. So here you can have one person serving all three of those roles. And then likewise, if the Title IX coordinator is only serving in that role and someone else is serving as the investigator, that investigator can under the new regulations, also be the decision maker. So that's a fairly big change mechanically. The new regulations require that your grievance process have some way for the decision maker to assess credibility of the parties and the witnesses. So one of the main problems, in my view, of the 2020 regulations was that it was very frequent for the decision maker, who was the person serving only that role, who had never spoken with any of the parties or the witnesses. It was difficult or sometimes impossible for the decision maker to assess the credibility of the parties or the witnesses. Now your grievance procedure has to allow the decision maker to somehow assess the credibility of parties and witnesses. One way to do that is the new regulations allow the decision maker to also be the investigator. So that gives the decision maker the opportunity to meet, hopefully in person or at least by video, with parties and witnesses, because having that face-to-face discussion and questioning session with the parties and the witnesses is an excellent way for the decision maker to assess the credibility of witnesses or the parties. If your grievance process, or in a particular case, if you decide that your investigator is not also going to be your decision maker, if the decision maker decides that there is an issue about credibility of parties or the witnesses, then under the new regulations, the decision maker may arrange to have his or her own questioning sessions in person or by video, or at least by telephone, with parties and witnesses, and ask those people additional questions, look at their demeanor while they're answering questions, and that way make an assessment of their credibility. The last slide in my part of the presentation is a change in the publication of training materials. Under the old 2020 regulations, you're required to post your Title IX training materials on your website, so anyone can go onto your website and view them. Now, with the new regulations, you don't have to post your training materials on your website. You can still do so if you want. But if you do not post your training materials on the website, If anyone asks to see them, treat it as a public records request, and people are there. You have to provide a copy of your training materials to someone if they request it. That is the end of the Title IX part of the presentation. We're going to take questions at the end of the webinar. And now I would like to turn it over to Sherri Warner and Aaron Ross for the next part of the webinar.
Okay. Good morning. I'm Aaron Ross, and Sherri and I are going to talk a little bit about the different legislative happenings in Ohio right now, and how they're going to affect the school districts. So our first section is really on two. We're going to focus on two religious bills. The first one here is one that has actually been around for quite some time, but there's going to be some proposed changes for that. The release time for religious instruction is an Ohio law that currently permits districts to adopt policy that authorizes students to be excused from school to attend a course in religious instruction. There's some requirements for it. You have to have written consent from the parent. The sponsoring entity has to keep attendance records and make them available to the school. Transportation is the responsibility of the sponsoring entity. They have to make the sponsoring entity, that is, has to make provisions for and assume the liability of the students. A big one, no public funds and no public school personnel are involved in providing that religious instruction, and the student responsibility the student has responsibility for missed work, and they may not be released from core curriculum subjects. So thanks, Vincent. This really stems from a Supreme Court case, Zorak versus Clausen, from quite some time ago, 1952 actually, and it dealt with a similar situation but involved New York City. And this program allowed public schools to release students during the day to go to religious centers or for religious instructions. It was challenged in finding that the program was lawful. The Supreme Court really relied on the First Amendment not requiring separation between church and state in all aspects, and focuses that it's on the First Amendment provides that there's no establishment of religion and no prohibition of the free exercise clause. And so that there's not this complete separation and allows for this program to occur. As we talked about before, Ohio has had this, I believe since 2014, have had the release time for religious instruction. And it's been permissive. School districts are allowed to adopt a policy if they feel that's right for their district. House Bill 445 is one that we have pending right now, and it would require school districts to adopt a release time policy. So this is a big change, right? It would take away the discretion of the school district and require that they have a policy and allow students to leave the school during the school day for religious instruction. I think some of the underlying policy for this and some of what we saw in the some of what we actually saw in the proponent testimony is focused on that without having these policies and without requiring these policies, we're essentially depriving people of their right to practice their religion. And so that's kind of the motivating factor there. So that's one that we currently have pending. The first hearing, I believe that one, Sherri, that one's has had its first hearing, right? It's with the committee.
It's had a couple of hearings. There were significant numbers of proponents at the second hearing, and it is still pending in the House Primary and Secondary Education Committee.
Thank you. So along the same notes of religion in our schools and bills pending, we also have House Bill 445. So this bill would require school district to adopt a policy authorizing a student to be excused from, I'm sorry, off here. Senate Bill 49 requires a policy that reasonably accommodates sincerely held religious beliefs and practices, allows for 3 excused absences for religious expression, and you get 3 of those days per year. So this one is Senate Bill 49, and under the policy, the schools may not impose academic penalty as a result of an absence. Consider these absences in determining absence hours for parental notifications. So this type of absence can't have a negative effect on that. And then you can't unreasonably withhold or deny an excused absence for any religious holiday, festival, or observation. There's going to be some additional oh, did we lose control? I think we may have lost control of the slide there. So requires, there we go, thank you. So you have to provide alternative accommodations for students who miss exams or other requirements. If they're absent for religious expression, you have to allow the student to participate in extracurricular activities. So we're talking, sports, programs, right? And then the policy has to be posted on the website and include a non-exhaustive list of those holidays, festivals, religious observations that will not be unreasonably withheld or denied. And I believe the Department of Education and Workforce is also required to establish a similar list for school districts, that the policy must be communicated annually to our students and parents. And they also require a grievance procedure regarding the implementation. So if a student is denied, there has to be a grievance procedure in place at the school district for that. So it was introduced February of 2023, so it's been hanging around for a while here, but it did pass the Senate in April of that year. It was referred to the House Primary and Secondary Committee in May of 2023. Most recent hearing was September of this past year, so we're on our 3rd hearing. And so the bill, it's moved along a little bit slowly there, and is, potential moving forward to be passed. So. Now, the Protect All Students Act is our next one. And Susan kind of alluded to this conversation in the discussion of Title IX. And this one is really, I think, has been kind of referred to generically as the bathroom bill. But it requires each student restroom, locker room, changing room, or shower room that is accessible by multiple students at the same time must be designated for a specific biological sex. So the male biological sex or the female biological sex. The proposed act does provide a definition for biological sex. It has changed, I think, several times over the course of the hearings and going through this process. But it's the condition of being either female or male is the current definition they have there. And it does provide that the sex listed on a person's official birth record may be relied upon if that birth record was issued at or near the time of the person's birth. So kind of a limited definition there for biological sex. It allows for accommodations for the use of single occupancy facilities or controlled use of faculty facilities in special circumstances. So it does provide a little bit of that special circumstances, but this is definitely kind of, I would say, on a head-on collision with what we saw in Title IX, which is, going to provide or require, I think, a much more broad approach to that. The other part of this is it prohibits male and female students from sharing overnight accommodations with members of the opposite biological sex. So obviously, going back to that, specific definition of biological sex there. So I think this is definitely, a thing for our transgender students that's going to be a difficult for districts to navigate, especially with the Title IX new provision. So if this passes, we're going to have to kind of work through how to implement and how it interacts with our Title IX requirements. So it was introduced in the House in May of 2023 and referred to committee in June of 2023. Now this has had a number of hearings already, and like I said, the text of the actual bill has been changed a little bit, but it's on its 5th hearing, which was held pretty recently, April 10th of this year. So. Now, to move on to one that's actually been passed, we've got the cell phone policy requirement. This was House Bill 250. Most recently, it was signed into law for May 15th of 2024 and effective August 14th of 2024. It requires that the Department of Education and Workforce develop a model policy, which they've already done that. That's available on their website, and I think they've been advertising that and putting that out in their communications to school districts that model policy is available. So it requires school districts that by July 1st of 2025, they adopt a cell phone policy. That policy has to emphasize that student cellular telephone use be as limited as possible during school hours, reduce cellular telephone related distractions in classroom settings. And then there's some provisions that allow for the use of cell phones when those are included in a student's IEP, if that's determined to be appropriate. So I think, with our cell phone policy bill here, it's pretty general in terms of what is required, but does allow the school district kind of that flexibility to develop a policy that's appropriate for their own district. One of the, I would say, very interesting bills that is currently pending is House Bill 206, and it involves the expulsion for actions dangerous to others. So this is a very kind of, I would say, structured and prescriptive approach to broadening student expulsion and flexibility for the district. So it permits school districts to develop a policy to expel a student for not more than 180 days for actions that pose imminent and severe endangerment to the health and safety of other students or school employees. So the superintendent is required to provide conditions for reinstatement for those students, which must include an assessment by a psychiatrist, psychologist, or school psychologist. And the purpose of that is to determine whether the student poses a danger to themselves, to other students, or to other employees. It does specifically define imminent and severe endangerment. And it's going to be kind of some of the similar things we see in the revised code already: bringing a firearm or knife capable of causing serious bodily injury, committing an act that would be a criminal offense if committed by an adult, which results in serious physical harm to persons or property, making a bomb threat to a school building or a premises, and making articulate or verbalized threat that would lead a reasonable person to conclude that the student poses a serious threat. So we do have kind of a specific definition here of severe endangerment, which would help superintendents, school districts enforce the policy with that specific definition there. So after the suspension, the superintendent is required to assess whether the student has shown sufficient rehabilitation, meaning that the student has met conditions for reinstatement that are required to be set, and that they no longer pose a danger. So if a student has shown that sufficient rehabilitation, they have not, shown that sufficient rehabilitation, then the superintendent can extend the expulsion for 90 days. They have to develop, additional reinstatement conditions to provide to the student. Those can be the same conditions as before, but they have to be provided again to the student. So you don't have to come up with new reinstatement conditions each time. They can be recycled. They just need to be provided. But I think the interesting part is it provides for no limit to the number of 90-day expulsion extensions that can be added on if the superintendent, through that assessment is determining that the student still poses a danger. So it was introduced in the House in June of 2023, so about a year ago. It was passed by the committee in November of 2023 and is awaiting a vote by the House. So this bill is currently in the House, waiting on that vote. I think it's got bipartisan support in its development. So, this was, I think, one to keep an eye on that I think both parties are behind. So Senate Bill 168 be the last bill that I'll discuss here. So it provides some legislative fixes and clarifications. So there's a number of different things contained in this one. But one of the major changes is that it allows school districts essentially not to use OTES. So it permits them to use an alternative teacher evaluation framework that is created or adopted by the school district. So school districts would have the flexibility if they want to use OTES, they could continue to do that. If they wanted to use a different evaluation framework, then they would have the ability to do that. Additional changes, some licensure things here. So the administrator license and the alternative superintendent license would no longer require a master's degree, instead would only require a bachelor's degree. This one also provides a range of time for the intra-district open enrollment lottery. Before, it was very specific in terms of the day in June that this lottery had to be conducted. I believe that was in our budget bill this past go around. But now it provides a wider range. So if this bill were to pass, that would just need to be conducted, that lottery conducted between April 1st and the first Monday in June. The year before that, the request for open enrollment. So looking towards that next school year. The last thing there, able to go back. Removes the seniority preference when determining layoffs pursuant to a reduction in workforce. So that seniority provision would only be available, would only be considered if the employees have comparable evaluations.
And to add a little bit of flavor to a couple of the bills that Aaron discussed, the bathroom bill, things to think about if this bill should make it through. The bill is generated out of concerns that districts will not have their liability insurance if they are sued because they have denied a transgender child the use of the bathroom of their preference, as would be required currently under Title IX. Members of the General Assembly were concerned and wanted to make it definitive in law that should a district decide to go down this path, and with experiences we've had in some districts who have gone down the path of allowing a transgender child to use the restroom with which they identify, loss of local levies, significant losses, sometimes as big as 80% failure rates. The GA felt they needed to step in and make it definitive to support those districts who do not want to allow, or whose communities do not want to allow the child to use the bathroom with which they identify. They are fine with those children using gender neutral bathrooms, or those students using gender neutral bathrooms, but they are not supportive of the use of the locker room or of multi-use restrooms for which they identify. And so districts are starting in some more conservative areas of the state to push back and to not allow this to occur. And there were concerns because there were some letters from insurance companies letting the boards know that should they do this, their liability insurance against suits would not protect the district because they were in violation of federal law. So by passing this state law, there is some hope that this would protect those districts. The other bill I wanted to add a little bit onto is the Senate Bill 168. And one of the challenges you will have should this bill become effective, and it very well could, given where it is at within the Senate and House process, is the impact on your collective bargaining agreements. The bill does not address collective bargaining agreements or what would happen. So to the extent that you have the OTAs in your collective bargaining agreements and how that's going to operate, you may have to go back should you want to change and renegotiate some provisions in those agreements in order to implement your own evaluation system. So having added that, I'm going to go on to House Bill 8. And the primary purpose of House Bill 8 is to protect the fact that a parent has a fundamental right to make decisions regarding the upbringing, education, and care of their child. This bill was a primary bill for the House. It is one that was introduced immediately after the House went into session by Representatives D.J. Swearingen and Sarah Carruthers. And it is the Speaker's belief that this is a priority that needs to be moved. We need to get this into the revised code law, as there is an impression that districts are stepping in and replacing the parents in certain circumstances. So should this bill pass, districts will need to adopt a policy within 120 days of the effective date of the bill that promotes parental involvement in the public school system. The policy has to include all of the following: ensure that sexuality content is age and developmentally appropriate. Now, age and developmentally appropriate are defined in the bill. Sexuality content is defined as any oral or written instruction, presentation, image, or description of sexual concepts or gender ideology. It does not mean instruction on venereal disease, child sexual abuse prevention, or sexual violence prevention. So to the extent that you are required to provide those in all of your grades, those types of instruction would be allowed to continue. It does require to the districts that they disclose to the parents instructional material that includes sexuality content. And this would need to be done before that content is taught. The parent may then request that the child be permitted to take an alternative class. What is not in the bill is who decides what the alternative class is. There's also a gap in the bill in deciding where that alternative class will be held or what will be done with the student during the time that they are out of their normal classroom environment. The bill does require, so part of your policy will need to require that you notify students' parents of any change to services that the district is providing to the student. This includes counseling, or if you're monitoring the child regarding mental, emotional, physical health, or you must let the parent know if the district can continue to provide a safe and supportive learning environment. The last statement, I think, could be somewhat problematic for some districts in that it may place a higher burden on you to develop anti-bullying provisions and what you will do to address bullying of a child. The district can decide in what manner they want to notify the parent. It does not necessarily have to be in writing. This is something that you can decide when you're implementing your policy. The policy also must reiterate that it is the parent's fundamental right to direct their child's upbringing. Further, the district cannot inhibit parental access to the child's education and health records that are in the district's possession. An additional provision prohibits district staff from encouraging a child to withhold mental, emotional, or physical health information. Personnel are also prohibited from discouraging or blocking parental notification. The legislation does specifically say that nothing in the policy can conflict with the school's responsibility to report unlawful abuse or neglect as required under 2151.421 of the revised code. Now, this is where the bill is seeking or having quite a bit of controversy. There is concern that the bill will force districts to out their students who are looking at an alternative gender or sexuality to their parents, which then may create a dangerous situation for the child in the home. So especially with the school counselors have come out vehemently opposed to this bill, as have all of the statewide groups is supportive of the LGBTQ community. The bill does require the district to develop a plan to obtain parental permission prior to providing any health care service. It exempts from that requirement the vision, hearing, and health screenings, which you are currently required to do under the revised code. This includes notifying parents at the beginning of each school year of the healthcare options or services that the school provides or facilitates, and the parent's right to withhold the consent for these services. So this would be something that would need to be on your website or handed out to your students or to take home to their parents within the first couple of days of school starting. Giving consent for treatment for the child does not waive the parent's right to access the health records as delineated above. And if the district is required to provide the service under state law, they must notify the parents of other options which may exist outside the district. The policy must state that these provisions do not apply in emergency situations. So if the district would be required to provide a service such as a service for in support of an IEP, the district also must allow the parent to know or required to notify the parent where the parent could seek alternative support for the child. It does not, in this legislation, require that the district pay for any of that alternative support. It simply says that the district must provide knowledge to the parent that these alternatives exist. And again, the policy or the bill does specifically exclude emergency situations. Obviously, if a child has been seriously injured, they do not want a delay of notifying the parent prior to calling 911. The bill permits parents to file written concerns regarding any of the above policies should they believe the district has failed to comply with this statute. The policies must include a process by which the district will address the parents' concerns, and that must be done within 30 days of receipt of the concern. If the district fails to address the concerns within 30 days, or if they deny or do not resolve the concern to the parent's satisfaction, the parent can then appeal the decision to the school board. The school board must hold a hearing and make a determination regarding the parent's concerns. There is no additional step currently in the legislation with regards to what happens should the parents still be unsatisfied with the decision made by the board. In testimony, the sponsors indicated that the parents would have the ability to vote board members off after the fact. My guess would be that some clever attorneys will figure out ways to pull this into the court system. So those are the provisions that must be within the policy. The bill goes on to require that the policy must be prominently displayed on your website for everybody to access. The bill was amended in the Senate to require or prohibit the instruction of any use, any instruction using sexuality content in grades K through 3. This is commonly known as the Don't Say Gay bill, which came out of Florida, and the provisions mimic very closely those provisions which passed in Florida a couple of years ago. Bill passed out of the House and was done on a party line basis. It came out of committee party line, it came across the floor party line, and it was sent to the Senate, where it was sent to the Senate Education Committee. The Senate Education Committee has amended the bill several times. And one of the major changes for the bill was when Senator Brenner, who has been trying to pass changes regarding community schools, amended all of his desired changes for those community schools into this bill. This bill was also eyed as a vehicle to pass the cell phone bill. So that indicates the intent, I believe, of the General Assembly to move this before the end of this General Assembly. The Senate will move it, and I believe that the House will probably go along and concur to all of these amendments. The one thing to note with regards to the charter or the community schools, as the language does provide several expansions of community schools' ability to sponsor additional entities. Currently, sponsoring entities are limited to the number that they can sponsor, and this bill would increase it significantly. And it also includes several provisions loosening requirements around e-schools. Those e-school requirements were placed into the revised code after the episode with ECOT and all of the money which was lost by the state paying the electronic school for students who were not successfully or who were not attending school at all. So he is going back and trying to remove some of those provisions so that these e-schools have more flexibility as they operate. I think one thing to be concerned about or to think about should this legislation pass is not only will the districts need to develop the required policy, but you're also going to need to develop significant professional development. Your staff is going to have to understand the parameters of what they can and can't say, when they need to notify parents, and how that needs to be addressed. This could be particularly tricky with your K through 3 staff members, because you're going to have to decide how they answer questions when addressing questions from children who are asking about maybe another student or another child in their class who has an alternative family structure. So that will be something that the districts will have to think about and align with as you're doing your professional development and implementing this particular bill. The other area that I am going to cover is Ohio's property tax statutes or property tax proposals. So currently, there have been significant concerns throughout this General Assembly of the increasing property valuations in the state. While obviously increasing home values, increasing property values are a positive, it also can create increases in the property taxes paid by landowners. The property valuations in some parts of our state are on average increasing between 30 and 40%, which would be significant. Now, clearly that does not correlate to a direct increase of 30 to 40% of property taxes. However, we are seeing pockets of areas, particularly areas that are going through redevelopment, where property taxes are increasing, I'm sorry, property valuations are increasing between 200 and 300%. And those types of increases are greatly increasing the property owner's taxes. What is driving all of these property taxes and concerns? Many individuals in the General Assembly believe that there are too many entities that have authority to place levies on the ballot. Some of the entities, in addition to school districts, include children's services entities, developmental disability boards, Ohio's alcohol and mental health addiction boards, aging boards, are all able also to place levies on the ballot, as are townships can place property tax levies on the ballot to fund police and fire services. So there are several entities that can or do have the authority to place these levies on the ballot, and that our current system, particularly with the replacement levies, which we will get into in a bit, allows a waste of resources because they know they can easily pass the levy revenue, or they pass the levy issue, increasing their revenue. Now, I'm not sure how many of these members have tried to get a levy passed. I'm sure many of you have had concerns or difficulties when you've tried to pass your levies. We do run about a 50% failure rate, if not a little higher, of school levies in the state on an annual basis. So the ability to increase your revenue in this way, I think, is not quite as great as many members of the General Assembly believe, but nonetheless, that is their current belief. Other concerns that have been brought up, besides the increase in valuations and so the increase in property taxes, are that multiple types of levies create confusion among the voters. There are renewal levies, new levies, replacement levies, and that people don't understand what they're voting on or for. Local debit, another issue that is driving property tax concerns, and this is actually driving some of the increases in property taxes, are local governments using tax abatements to drive economic development strategy. We see that in areas where they may provide a tax abatement, a property tax abatement for individuals who buy homes in a community that they're trying to revitalize. Those homes then are torn down and they build new homes, which are worth a great deal more money than the homes that they tore down. And those individuals, for them going to that neighborhood, are offered 15-year full tax abatements by the city. Well, all that does is transfer the burden of the tax to other individuals paying the tax, especially homeowners immediately around them, who will now see a significant increase in their valuation. And so the individuals who have the least ability to pay the tax are the ones that are going to have to pay the tax. Another area where we've had some significant shifting in the burden of tax is with the General Assembly's movement over the last 15 to 20 years to eliminate different types of tax. The elimination of the tangible personal property tax definitely shifted the tax burden over to more residential payers. The General Assembly filled that gap, as you are all aware, for a period of time, but that transition has ended, and now districts are solely reliable on their tax base in order to cover those costs. So that has been a shift that has caused residential taxes to increase as well. Other concerns are that new development naturally creates increased property valuations. And as I said that earlier, that's great news, except to the extent that it is also creating significant increases in homeowners' tax bills. And then the biggest concern that the General Assembly is voicing at this time is that with all of these factors in place, it is creating a higher and higher burden on those property tax owners who can least afford to have those types of burdens. And those are low-income homeowners who now are faced with losing their largest asset. So in response to all of these concerns, the House and Senate created the Joint Property Tax Review and Reform Committee. It has 5 members of the House, 5 members of the Senate, It is divided politically, 2 Democrats from each house, 3 Republicans from each house, and it is co-chaired by Senator Bill Blessing and Representative Bill Romer, both of whom are the chairs of the respective House's Ways and Means Committee. This committee met and has had 6 hearings. The hearings have all been exclusively from invited testimony only. They started with an overview of what the current tax laws are by the Legislative Service Commission, giving them a background, including why and how House Bill 620 was passed, issues around the tangible personal property tax when it was eliminated. It included also testimony from the Department of Taxation and their role in collecting and implementing the tax. They've heard from economists who are talking about how the tax is falling on different payers in different ways. That individual particularly addressed the tax abatement questions. They heard from the county auditors who implement the tax, the Ohio Chamber and the Ohio Business Roundtable, the Farm Bureau, who all represent business interests. The Farm Bureau does have significant concern over the increases of the CAUV formula, which is how farmland is taxed. We also had local government groups, the County Commissioners Association, the Township Association they heard from. They did hear from OASBO and BASA. And finally, they also heard from some public policy groups like the Buckeye Institute and Policy Matters Ohio. The Buckeye Institute is on the conservative side. Policy Matters Ohio is on the more liberal side. That is not an exhaustive list. They did hear from others, but that is a highlight of who they heard from. And at the time that they started this committee, the hope was that they would be able to provide a pathway forward to, in essence, clean up the property tax laws and kind of level set where everybody is. The last time this was done was in the early 1970s, and the belief is that this needs to be done now. After hearing a lot of this testimony, it became clearly evident that the system has grown and is complex enough that completely going in and changing the entire process and how property taxes are assessed and collected and divvied up would upset multiple apple carts, creating a lot of political challenges. And there's just not the ability to undertake that type of wholesale overhaul at this time. So instead, the committee has decided that they are going to try to nibble around the edges and assist taxpayers who are having challenges paying their new property tax. We have seen an incredible, going back, some of the recommendations that came out, the business community would like actually more targeted abatements, which is interesting given the concerns of the economists who said we're already using too many tax abatements, but the business community obviously would like additional ones. And they would like to see increases in the homestead exemption. They also would like to reevaluate and review levies. During their testimony, they did reference school funding and the impact of property taxes that school funding has on property taxes, and made some suggestions around changing school funding to levy or to eliminate the challenges in the property tax field, space that is caused by the school levies being, or the schools being funded so much by property taxes. They also have asked that the General Assembly evaluate the way that challenges to valuation are handled. There was a change in the last General Assembly. You lost your ability to challenge a tax valuation, and only an individual who owns the property can challenge that valuation. Local governments cannot step in and challenge any types of valuations unless they meet a pretty high bar, which is that they believe that the valuation is off by more than $500,000 and that property changed hands in an arm's length sale in the last 2 years. So they're wanting to further curtail individuals from, or third-party entities from intervening in tax valuations. Some districts, some taxing entities found ways around the laws that were passed the last time, and so they're trying to close those loopholes that were created. The business community also supports keeping the CAUV formula in place, which lowers the taxes on farmland. They are supportive of the LIHTC credits. These are credits that are used to build affordable housing communities for individuals. And they they've asked to standardize the training that those assessing property taxes are required to have, so that it is more evenly, properties more evenly assessed across the state, and that everybody is looking at the same issues. Local governments, on the other hand, as you can well imagine, are very concerned about how this funding is going to impact their services and their ability to provide services. And they are looking at different ways to address the challenges within their local communities. Finally, the public policy people are asking that the state consider what they call a circuit breaker. This circuit breaker would determine a maximum percentage of an individual's income that could go towards property tax. And once the individual had paid that percentage, then the state would come in and repay the remainder of the tax owed. Property tax is the one tax that is not income dependent, so it does not matter how much you make, unlike income tax or even sales tax, because that's determined by how much you can spend. Property taxes go up or down regardless of your ability to pay. And when you look at the percentage of income that goes to property taxes, individuals who are in the lower income space pay a far higher percentage of their income, while those in the upper income brackets pay a very low percentage of their income to property taxes. So, having come out and heard all this testimony, as I said, they want to try to nibble around the edges. There was also a significant attempt to address the property tax increases that people saw during the 2023 tax year. None of those bills made it across the line, although there could still be some attempts to assist taxpayers who saw those significant increases by providing credits for them in future years. There have been 27 bills introduced between the two chambers. And the majority of these bills do address homestead exemptions. They add classes of people who would qualify. Some of them add, one of them would add disabled veterans as being able to receive a homestead exemption automatically. Another one would ensure that the spouse of a law enforcement officer who died in the line of duty continues, or who was injured in the line of duty continues to receive that property tax exemption even after the first responder's death. They are also trying to index the homestead exemption to the CPI or another model, which would allow them to increase. Currently, that amount is set in the revised code, and as we know, with property tax valuations going up, some of these are increasing, and individuals who qualified for the homestead exemption will no longer qualify, placing a significant burden on those individuals. So we're seeing a lot in the homestead expansion place. Yesterday, the General Assembly passed the bill, or the Senate passed the bill, which would allow disabled veterans to receive the homestead exemption. Additionally, House Bill 496 would modify the way that county auditors are able to set valuations. It does also require some new training standards for people who are doing the assessing, which could help with uniformity across the state. There are bills that the Joint Property Tax Committee is looking at implementing themselves, tinkering around the edges, providing some changes to charity, people who are exempt from property tax because of charity use, when those notifications or when the property changes hands or changes, the use of the land changes, who has to notify who when. Some standards around tax abatements are also being discussed. So there are several bills in that space. There is a bill that would cap property tax increases to 4% annually. This is a resolution because that would have to go to the state ballot. And all of these bills are behind this slide. The one that will most significantly address districts is House Bill 344, which will eliminate your ability to place replacement levies when a millage expires. Members believe the use of the replacement levies allows taxing entities to increase their revenue without sharing that the millage that they are passing increases their taxes. They believe any new revenue should be designated as a new levy. This bill, I believe, will pass the General Assembly before the end of 2024. I'll now hand the webinar off to Tom Allen and Lisa Burleson, who are going to discuss current law regarding social media, transgender students' rights, and what's happening in administrative agencies.
Well, good morning, everyone. I'm still waiting for my slideshow to pop up, and we'll be ready to go as soon as it does. All right, looks like we're about ready to go at this point. All right, so what I'm here to talk about is not pending legislation, but a legal update relating to a Supreme Court decision that the United States Supreme Court issued earlier this year. And it has to do with something you probably never dealt with, which would be people that are posting on Facebook pages or Twitter pages or whatever social media of the school board that you're either working for or the superintendent's page, etc. So let's back up for just a second. So hypothetical, you're a board member, you have a Facebook page. You were not a board member at the time, it's just your personal page. You're sharing personal photos. What happens next? Well, you run for school board. And at the time, probably there might be some posts if you're being very active on social media about, your policies, etc. But you've been now elected a school board member. And so you kind of are wearing two hats. You're a person, a private person, you have your private persona, and you're also a public, basically a public entity, not quite, but I think you know what I'm talking about there. Now you're a school board member and you can post some school related posts and you can post some personal posts. And that's what you're doing. One of these things might start causing some people to express their opinions that might disagree with what you're either announcing or posting about. In this case, let's say something that kind of drew a little bit of, let's say, strife in the past few years was a masking policy or vaccination policies. And you post something about that and people get upset about that and they post on your page not kind things about you and or the policy and about the wisdom of instituting such policies. So the question is, can you call your attorney and you say, can I delete these posts because they're calling me all kinds of names and I don't like it. And I especially don't like it sitting there on my Facebook while everybody, my friends included, are looking at my Facebook page. So our question is, can we do that and how? Well, the Supreme Court just said, here's how you do it. And the good thing is it was unanimous, which is nice. And it was also, I think, in my opinion, it was pro-public employee. The prior tests weren't so clear, and that's why the court took this up. So it was considered previously like a Twitter account was the public square. And if it was run by a public entity or an elected official, you had to be very careful if you were going to block someone, because that's the First Amendment. And if you were basically blocking someone's First Amendment speech for disagreeing with the content of their speech, that's a First Amendment violation. So I previously talked about that when there was a kind of a well-covered decision where they basically said, and I don't know who the public entity or public elected official was, that said, hey, you can't block this person. This is a public square. And I wrote a little article called "Don't Block Me, Bro." And I thought it was funny at the time, but of course it was based on the "Don't Tase Me, Bro," which no one knows anything about anymore. So it's kind of stale. So let's work on the next issue that we had, which was there were two cases that came out, which kind of had slightly different analyses on how to analyze this question. Two cases aren't a big deal unless they come from two different circuits, and they're kind of the final answer legally in each of those areas of the state or the country. So the first case was a Sixth Circuit case, which governs our area. It was Linke versus Freed. Freed was the city manager for a city up in Michigan. And of course, it had to do with the pandemic, and there were some announcements that Linke made or that Freed made regarding that. Linke is unhappy about that. He doesn't like how the city is approaching the pandemic, probably closures, wearing masks, things like that. And he expresses that on Freed's wall. So Freed isn't very happy about that because I'm sure they probably used some choice language. And then he blocks Linke. And district court, when Linke sues Freed and the city, district court says there's no 1983 lawsuit because basically this was a private page and the action taken is private. It goes up to the Sixth Circuit on appeal. Sixth Circuit says the same thing. It's like, look, it's a private page. He can do what he wants. And he did. So no lawsuit, go home, Mr. Linke. Similar situation, however, this one occurred in California in what's the Ninth Circuit. So you had the Garnier versus O'Connor-Ratliff case. School board members here, they've got their social media pages, their Facebook pages, etc. Same kind of thing. There were people posting critical comments. The trustees deleted those comments and blocked the plaintiffs. However, in that case, the district court said, no, you are liable to them under 1983. You are acting under color of state law, and you are blocking people from basically the public square based on the content of their language. And we don't like that, and we find that to be a violation. That goes up on appeal. Ninth Circuit says, no, they're absolutely right. You can't do that, school board members, and so you're liable. Now you've got two cases with two different outcomes in very similar situations. Supreme Court says we've got to resolve this. We got to try to figure out what the standard is going to be because these courts were looking at slightly different things historically, and let's get people some guidelines in the future. So what did some of the courts look at previously? This is just to give you a little bit of context. So where were the posts made? Did they come from your personal cell phone, or did they come from like a school issued phone? School issued phone kind of militates toward, okay, maybe it was a public post. Did the page, for example, a Facebook page, also link to a government website? I am Tom Allen, private citizen. I get elected to be a city council member. I mentioned that on my webpage. It's listed under About Me, and I link to the city's website. Again, that's kind of going to say this is probably a public website and or public post. What was the purpose of the page? Did I create it after I became a public official? Probably going to be public. So anything I'm doing is going to be as a public official, and that's when you run into problems. Other things they looked at, when were the posts made? So were they made basically off hours on the weekends, at night? If so, that's probably, again, we're going to say that factor militates in favor of it being a private post. Is my title on the page? If it's not, let's say it's just an old personal Facebook page that doesn't have my title, it's probably going to be a private post. Let's say I leave office as a public official or a school board member. Who keeps that Facebook page? If it is the school, then it's going to be posts made there, and actions taken are probably going to be done by a public official. And again, that's what we're trying to avoid, because then we don't have the state action that can get school board members sued. So how do we resolve that? That's a lot of things. And the court was like, no, this is not really what we want. That's not what we want the test to be. So the court is going to look at, is this part of your job functions or your job duties? is it part of the job that the state is asking you to do? And we don't really care about the post function. Kind of you do, but you don't. It's more about the public officials' duties. So here we have, let's say, a post about the mandatory mask policy. You're a school board member or you're a school administrator, and you say, look, we're implementing a mandatory mask policy. It's going to go into effect next week. That's probably part of the official duties, and any kind of critical comments should stay up there because that's going to be state action if you take them down. So were you, as a school board member or school official, speaking in your official capacity? If it's part of your job duties, then yes, you likely are. And then are you exercising that authority in the post? And that is literally the test that the court came up with, was, is it part of your job? And are you acting in your job when you're removing somebody's comment? They don't look at any of the other stuff. So good example here, pretty straightforward example. Everybody can understand this one. Let's say it's Saturday, there's a college football game going on, and a school board member posts "Go Blue," and you're an Ohio school board member. You happen to graduate from the University of Michigan. In Ohio, that's going to cause a little bit of strife, and you might get some comments that are critical of that. So that's clearly personal, though. Obviously, that doesn't have anything to do with your job. So you can remove comments that are basically critical of that because you're not acting in your public capacity. You're not a state actor at that point. So delete the post. Be careful of blocking those people entirely, because now you're kind of using a sledgehammer when you should be using a scalpel. Because if that page also, you post some things that are basically job related, they have to do with mandatory vaccinations or mandatory policies on masking, something like that, then that block person doesn't get to see those public posts, those with your wearing your public persona hat. They don't get to see those, and that could result in a First Amendment lawsuit. The Supreme Court mentioned that. They're like, look, you can delete, but be careful blocking somebody if there's a dual purpose page. And that's why when you'll see at the end, I recommend having 2 different pages if you can, if it's not too much trouble, and for that specific reason. The court also said, let's look at disclaimers. Are there any disclaimers on the page that say, hey, these views are my own, or this is my personal page. This is not anything to do with basically my position as a public employee or elected official. Court said that gives a strong presumption that the posts are private. So that's a nice little, I think, add-on that maybe not necessarily should be given the weight it is, because you can just kind of throw that tag on there anywhere on any post, and you're going to get a strong presumption that the post is private, and you're not taking state action if you remove it. So I like that from a standpoint of defending public officials. I might not have given it the weight that the court did, but we're going to take it. So my suggestion, as I mentioned, have those 2 pages, use those disclaimers, try not to blur the lines between what's a public page and a private page, or a public post and a private post. So that's actually it for my portion of the presentation. So I'm going to hand it off now to Lisa if she's here, or to Sherri if Lisa's not here yet.
We're actually handing it off to Aaron here, so I'm going to cover
Aaron.
the administrative updates here for you. So our first administrative update is proposed updates to the Children Online Privacy Protection Act, and there are new rules. So the Children Online Privacy Protection Act imposes requirements on operators of websites or online services that are directed to children under 13 years of age, and on operators of other websites or online services that have actual knowledge that they are collecting personal information online from a child under 13 years of age. So, very specific group of people we're talking about here. So it requires that certain websites and other online services that collect this information about these children, that they have to provide notice to parents and obtain verifiable parental consent before collecting, using, or disclosing personal information from children. Now, obtaining verifiable parental consent means they provide different ways in which they can do that. Credit cards, those questions that they ask you to identify yourself for different things. Those are the kind of things that they're talking about there. So they're looking for that verifiable parental consent in those types of fashion that we see with a lot of our online websites. So it also limits the personal data that the website and other online services can collect from children. It limits how long they can retain that data, and it requires them to secure the data. I don't know that we able to move this forward here. There we go. Thank you. So some of the key proposed changes are they require a separate opt-in for targeted advertising. So websites and online service operators would be required to obtain separate verifiable parental consent to disclose information to third parties, including third-party advertisers, unless the disclosure is integral to the nature of the website or online service, and firms cannot condition access to services on disclosure of personal information to third parties. The prohibition against conditioning a child's participation on collection of personal information. So the proposal reinforces the current rules prohibition on conditioning participation in an activity on the collection of personal data to make it clear that it serves as an outright ban on collecting more personal information than is reasonably necessary for a child to participate in a game offering of a prize or another activity. So one of the big things that we want to focus on here is the changes related to ed tech. And so part of the proposal codifies current guidance related to the use of education technology to prohibit commercial use of children's information and implement additional safeguards. The proposed rules would allow schools and school districts to authorize ed tech providers to collect, use, and disclose students' personal information, but only for a school authorized educational purpose and not for any commercial purposes. I think this is really a good opportunity for school districts with these changes upcoming to audit the programs, the technology that you're using to ensure that that student information is being handled appropriately under those agreements. We've got a lot of websites and applications that provide great tech for teachers in schools, and we just need to be careful and ensure that the student data is being used appropriately here. So definitely a good opportunity to audit that and to talk with our staff about what technology is appropriate to use and to have a procedure for approving, technology. So it's not student data being released by individual employees. So the next part is strengthening data security requirements. So the FTC has proposed data security requirements by mandating the operators establish, implement, and maintain a written children's personal information security program that contains safeguards that are appropriate to the sensitivity of the personal information collected from children and limits on data retention. So the FTC also would strengthen the rules, data retention limits by allowing for personal information to be retained only for as long as necessary to fulfill the specific purpose for which it was collected. The proposed change would also prohibit operators from using retained information for any secondary purpose, and it explicitly states that operators cannot retain the information indefinitely. The rule would also require operators to establish and make a public written data retention policy for children's personal information. Switching gears a little bit, United States Department of Education released 4 new fact sheets. This was in February of this year, and they're from the their Office for Civil Rights. The new resource documents are on students with disabilities, reminding students with disabilities in K-12 schools of their respective rights and responsibilities under Section 504 of the Rehabilitation Act. So those 4 documents are going to cover students with asthma, students with diabetes, students with food allergies, and students with GERD. So the fact sheets will explain when each of the 4 medical conditions trigger protections under 504, what kind of modifications an educational institution may consider to avoid unlawful discrimination against students based on each of the 4 medical conditions, and what an educational institution may need to do to remedy past discrimination against a student based on these 4 different conditions. So the students with asthma, this fact sheet addresses educational institutions ensuring that the educational environment is free of student asthma triggers, including during field trips and extracurricular activities. The fact sheet for our students with diabetes addresses mood, concentration, hydration, and restroom challenges that those students might face in educational settings, and suggests certain accommodations that institutions can consider putting in place to support those students. Now, our protection for the fact sheet for students with food allergies addresses ensuring that the eating and learning environments are free of food allergies, including during field trips and extracurricular activities. And then finally, for the fact sheet for students with GERD, addresses illness, attendance, concentration, and restroom challenges that those students might face in the educational setting, and suggests certain accommodations educational institutions can consider in place to support those students. Some other agency happenings: U.S. Department of Education, U.S. Department of Agriculture. They, on April 25th of 2024, published the final rule for child nutrition programs, meal patterns consistent with the 2020-2025 dietary guidelines. So these rules gradually phase in added sugar limits for the school lunch and breakfast programs, and update total sugar limits for breakfast cereals and yogurt to the added sugar limits. One big one here is the U.S. Department of Labor announced a final rule that expands overtime protection for lower paid salaried workers by increasing the salary thresholds required to exempt a salaried bona fide executive, administrative, or professional employee from federal overtime pay requirements. So it's really important here. It does not change current exemptions for teachers and school administrators. However, this doesn't mean it doesn't affect school districts. So we really need to consider any of our salaried employees that are, in positions like our EMIS director, maybe our transportation director, food services management, those types of unlicensed positions. So the old threshold was $35,568 a year. So on July 1st, that's going to go up to $43,888, and then on January 1st of 2025 increases to $58,656 per year. So and they use a different methodology of calculating. So really important there that we're looking at our employees that are in those types of positions and ensuring that that their salary is appropriate there and the provisions. Last one is the EEOC summary, or the pregnancy summary of key provisions. So this one is effective June 18th of 2024. So about 5 days from now. And it requires that most employers with 15 or more employees provide reasonable accommodation or changes at work for a worker's known limitations related to pregnancy, childbirth, or related medical conditions, unless the accommodations will cause the employer an undue hardship. Employers are also expected to accommodate a wide range of limitations once informed by the employee or their representative. And I think I'll turn this back over to Susan.
Okay, thank you, everyone. Thank you for hanging with us this morning, particularly in light of a bit of our logistical issues. We will absolutely get that fixed for part 2 of the webinar. There are no questions this morning, so we will leave it here. But on behalf of Sherri and David and Aaron and Tom, I want to thank you again for joining us, and I hope you have a great rest of your day.